I want to thank everyone for being here today, and we're going to set the record straight on the Supreme Court's affirmative action ruling in Students for Fair Admissions versus Harvard and Students for Fair Admissions versus the University of North Carolina, otherwise known as the SFA decision. These two cases were brought before the Supreme Court and by a noted voting rights and civil rights opponent, and he persuaded the Supreme Court's conservative majority to overturn 45 years of legal precedent that colleges and universities may consider race as one of many factors in their admissions process. The Supreme Court has long held that our nation has a compelling interest in fostering racially diverse campuses, holistic college admissions practices that narrowly tailor the use of race as one of many factors in evaluating prospective students were key to fostering such diversity in higher education. Research confirms that such admissions policies supported historically underserved students and contributed to a diverse campuses that also provided other students with a quality, well-rounded education. A year ago this week, the Supreme Court decided, with little regard for its own precedent or real-world consequences, that Harvard's and UNC's pursuit of these compelling interests were unconstitutional. The Supreme Court's decision is a significant setback in an effort to eliminate disparities in access to higher education and to ensure a diverse learning environment for all students. And worse, since the Supreme Court announced its decision to limit the consideration of race in college admissions programs, opponents to civil rights and equal opportunity have extended the case's rationale in areas of employment, contracting, outreach and recruiting, and others. We've witnessed state attorneys general to threatening corporations that have diversity and inclusion programs. Lower courts have invalidated private grants to close glaring racial gaps in business financing and 8A set-aside business programs, and attacks on black farmers seeking recovery from an institution of long-standing record from the fact that there's been a long-standing record of institutional racism in the Department of Agriculture. We've also seen nationwide setbacks on colleges and corporations' diversity, inclusion, and equity programs, DEI, diversity, equity, and inclusion programs, better known as DEI. Justice Sotomayor said it best in her dissent, "Ignoring race will not equalize a society that is racially unequal. What is true in the 1860s and again in 1954 is true today. Equality requires acknowledgement of inequality." So race-conscious admissions policies provided a counterbalance to factors that disparately impact students of color and students from poorer school districts, such as inequitably funded K-12 schools, racially biased admissions tests, developmental those who contribute to the college, and legacy admissions. All of those have disparate impacts, but you've got affirmative action on the other side, no harm, no foul. Once you get rid of affirmative action, all you're left with is a bunch of factors, most of which have racially disparate impacts. In Congress, I'm continuing to champion the Equity and Inclusion Enforcement Act, which, among other things, restores a private right of action for students and parents to bring disparate impact claims under Title VI. Parents and students deserve nothing less than to hold schools and federally funded programs accountable for providing all students with equal access to quality education. So I look forward to today's conversation about what we can do to reverse these inequities and ensure that public education, just as Justice Warren wrote 70 years ago in Brown v. Board of Education, that an opportunity of an education is a right which must be made available to all on equal terms. Similarly, I look forward to our expert today dispelling some of the myths that have spread since the SFA decision was announced last June, namely that affirmative action is illegal and that there are no longer any recourses to pursue equal educational and employment opportunities. And so we'll turn to our expert, Mark Miner, the Vice Chair of Racial and Ethnic Diversity at his firm's Diversity, Equity, and Inclusion Initiative. Attorney Minor is a senior counsel and focuses on areas of investment management and business litigation. He has extensive experience with federal and state finance services regulation. So thank you, Mark, for joining us today, and I look forward to hearing what you have to say. Mark Bonner.
In this committee for the honor or the opportunity to address this body on this very serious topic. The legacy of Howard University School of Law, my alma mater, calls on its graduates to go out into the world and to become social engineers in protecting the principles of liberty and freedom for all people, and particularly people of color. It's in that tradition that I have for my entire career been dedicated to the pursuit of equality for all peoples. Prior to this decision that Representative Scott has mentioned, racial equality was enshrined under the color of law, and a series of cases that began ostensibly with Brown versus Board of Education that looked back to the creation of lots of laws that began to subjugate people of color, particularly formerly enslaved people, going back to right after the emancipation with Jim Crow laws, and whereby domestic terrorism and night riders imposing notions of white supremacy of where black people could go and should go, what they could learn, and where they could earn. We have since then, fortunately, been able through court systems to get protections of inalienable rights that included the formerly enslaved people up to today. As Ranking Member said, up until just a year ago, Brown versus Board of Education stood for 70 years as a beacon of civil rights progress in the struggle for fair and equitable treatment of black people in their access to education. With the SFFA decision, the Harvard decision, I'll use by shorthand, we've seen efforts recently to pervert the Brown decision itself and to stretch its application far beyond the limits of its holding. And this stretching begins now to seem all too familiar. In recent years, we have seen an extension of efforts to put things under attack that have been solid rights for decades. DI programs, CRT, EOC, LGBT, ESQ. It seems like any acronym is automatically coming under attack. All of the anti-efforts seem to be there to create new barriers and to roll back any processes that have been made. And so this brings us to the discussion of the Harvard case. I use Harvard as shorthand, but as Ranking Member mentioned, there were two cases that were separately brought. They were actually brought by the same underlying interests under two different principles, one against Harvard for its admission programs and one against North Carolina. And the lower court in the Harvard case, you should know, actually affirmed the Harvard affirmative action, the Harvard program that was race conscious. And the North Carolina case that had not gone as far was swept up after that appeal was taken. Just 1 year ago, what have we learned? We know that institutions of higher learning have responded as they are responsible to do to the Supreme Court decision by evaluating their admissions policies. However, many anti-D&I interests have used this decision to argue that race-conscious policies, as Ranking Member mentioned, are illegal and that D&I has been outlawed, and that this decision reaches institutions far beyond education. None of these things could be further from the truth. So let's talk a little bit about what the decision says, and more importantly, what it does not say. So let's start with this. Race-conscious considerations have not been outlawed. We see those headlines lots of places. It's good for shorthand, but it is not true in any way. And you have to read the decision to know and understand. The Supreme Court decision, while challenging Harvard's methods to meet its aims and goals of fostering diversity, did not outlaw diversity or DEI or race-conscious considerations. So it's important to clarify what the Harvard decision says and does not say. And if you are a person in this room that is talking to constituencies who are repeating these narratives, it's important to know and understand exactly what the decision says. And those who are in the advocacy space need to know and understand that the machine that is out there to spread that information needs to be countered with facts. But this requires a little bit of background. Now, I'm going to try to resist my instinct to refer to my professorial roots, but we have to dive in just a little bit to the law. To understand what the Supreme Court was tasked with deciding, it requires an understanding that there are three levels of constitutional scrutiny. The first and most fundamental is called the rational basis test. It basically says so long as the statute or process has a legitimate state interest and is rationally related to, and there's a rational relationship between the means and the goal of the statute, it will pass constitutional muster. This is the type of case you typically see where someone says that this act or ordinance is violating my rights. This also relates to the exercise of government to perform various services where people say my rights have been violated or impinged. So the court will just look to that rule or that practice by the government or the state actor and say, was there a rational relationship between the display and the government protecting people by cabining individuals into a certain sector? And that is where most of the constitutional arguments are raised. The next level is a higher level scrutiny because much more personal issues are at stake. This is typical for gender, where the standard is that there must be not just a rational basis, but a substantial connection between the means to achieve the objective and the goal. But the one that we're really here to talk about today is strict scrutiny, which you may have heard. And this is the highest level of scrutiny of constitutional scrutiny. And it applies to fundamental and important rights that individuals have, including race and other fundamental rights. But we're talking about race today. But these escalating standards for infringing on individual rights recognize that certain suspect classifications of people that have historically faced heightened impediments to being afforded their constitutional rights deserve this additional scrutiny. So for strict scrutiny, which imposes the highest level, again, if a policy or program creates a rule, it can differentiate and consider race if it meets this constitutional bar. We often hear people say that a policy or a rule has infringed on their constitutional rights or trampled on their rights. The law, particularly this rational basis or intermediate or strict scrutiny requirement, says that there can be limitations on your rights if these particular tests are met. So let's talk a little bit about meeting those tests and how it applies to the Supreme Court decision specifically. So for strict scrutiny, constitutional rights are not violative or illegal so long as the rule or the policy in question does three things. One, it has to further a compelling state interest. it has to be narrowly tailored to achieve the objective, and it has to use the least restrictive means of achieving that objective. So this current iteration of the application of compelling state interest goes back to about the Warren Court and is well established. It also necessarily included, as Ranking Member Scott alluded to, is this notion of there being a compelling state interest of remediating past instances of discrimination or evidence of discriminatory policies. So the Harvard holding, if you read it, is instructive. I didn't want to break my back, so I only brought a small part of it. But the actual decision is not that long. It's only 40 pages. And it's one of the most transformative decisions impacting Americans that I can remember, certainly for civil rights and for people of color and those who are interested in civil rights movements. I think it's one of the most consequential decisions that I've seen in my entire legal career, and I commend you to reading it. In the decision, the court found that schools' asserted interest in educational benefits of diversity, both in enriching the university and the future for diverse students, was not sufficiently measurable to be upheld. So, listen, it said that that particular policy at that particular school was not sufficiently articulated to be upheld. It did not say that race-conscious decisions are illegal. It just looked at the facts and circumstances under which the Harvard decision based its positions and determined that that case was inadequate. And we'll talk a little bit what that means. The catch-all that the court usually uses if there is some ambiguous opportunity that they want to use or exploit is exactly that point. And the court said that they failed to articulate a meaningful connection. That means that there could even be a meaningful connection at Harvard or at UNC, but that as presented in the case, that they didn't meet that strict scrutiny burden. Thirdly, the admissions policy, they say, discriminated by disadvantaging certain students' chances of admission and by stereotyping minority students by assuming that their race alone would bring with them experiences that would enrich university life without examining the lived experience of that individual person of color. This is one of the most, I think, controversial points of the decision, most notably highlighted by Judge Thomas's concurring opinion, which is interesting because it's 3 times as long as the written decision. He had a lot to say about it. And fourth, and this is where I think we may be able to talk today about opportunities going forward, is that they indicated that any race-conscious decision must have a logical ending point. And they reached this by looking back at another case over 20 years ago now that said that no policy that is using race should be able to go on forever. And it kind of threw out this line. And I won't go, we'd be here forever if I'm citing all the case law. But essentially said that 25 years from now, we should be beyond the place where we need to have race-conscious decisions. And so the fascinating thing about this decision, if you read it, is that the majority latches on to this 25-year expiration date and ignores the precedent to that. If conditions are so that it is no longer needed. So the court's decision, importantly, does not require institutions to ignore race when identifying and admitting students for outreach and recruitment. So let's talk a little bit about what institutions can still do. The court expressly conceded, sometimes buried in concurring decisions, but it's all there, An institution of higher learning can collect demographic data about applicants, about the admissions process, about enrollment, and about retention, all relating to race. 2, it can accept applications that reference race. In fact, there appears to be no prohibition of asking an applicant to consider whether their experience and their race, whether that is minority or not, has impacted their life or their ability or their fitness or their ability to contribute materially to the college or university. And so that's to say that if an individual fills out an application and includes in an application a personal statement, and in that personal statement are talking about the ways in which their lived experience as a black person or a brown person or a white person has impacted or affected, they believe, their abilities, their talents, or things that they can contribute, that can be included in an application, and that doesn't have to be ignored. Evaluation of admissions policies. The court concedes that in order to effectively evaluate your own program, you need not stop accepting demographic information about your applicants. It does expressly say that those racial identities cannot be the basis upon which one is admitted over someone else. But it does concede that if you're going to do an evaluation, that information can be collected. I believe that this is one particular data point that has been distorted significantly. And finally, you can investigate whether the mechanisms of your admissions process are inadvertently screening out students. And that concession means the only way to do that is to collect the very information upon which those decisions can be made. If you read the decision, it talks a lot about the testimony of the admissions director at Harvard, who essentially says, we look at the admission rates of people of color of the existing year against the prior year, simply to see whether the rate of application and admission and people making their final cut before they do all the offers and acceptances are trending up or down as against last year. The court was very critical of that. And in essence, it said that that decision in looking at the binary measure as by race of one year against another was tantamount to making a decision to admit somebody on the basis of race. And they talk about a 5-part criteria that the committee, the initial committee that does a first review and a second review and it goes forward to the committee, uses to create an aggregate score for a student. And for those who have been historically disadvantaged and marginalized as they saw them, this is not just for black students, one of the categories that they would consider is race. And that would come with a point evaluation. And so they were really critical of that. The basis of the Harvard and North Carolina challenges were predicated on two different things. You should understand that the types of discrimination under scrutiny and what laws prohibit and don't prohibit also involve whether or not the institution creating the policy is a public or private institution. Title VI challenges relate to challenges where federal dollars are being used to further a policy or an objective, and that provision says that if you're taking federal funds, that you can't discriminate through the utilization of those programs. The other provision that was analyzed in the case was equal protection. And equal protection just essentially says that all individuals are entitled to equal protection under the law. Most people don't know this if they haven't studied any particular history or constitutional law. But it's even referenced in the court's decision. In fact, Chief Justice Roberts concedes that after those words were enshrined, that America basically ignored those rules for black people for nearly a century. But that decision does not concede that the fundamental policy of using laws to remediate past forms of discrimination is a practice that they would uphold. What I think I would most like to do is to engage the audience in some conversation, but let me leave you with a few things about this decision. My law professor, the late great J. Clay Smith at Howard University School of Law, always said, you got to read these cases. There's really no way around understanding or refuting misconceptions that often become bullet points, talking points, headlines that in today's world will go around the world twice as fast as the truth. But you have to know the facts to counter them. For those of you who are vociferous readers, I will go back to this the point. Chief Justice Roberts' decision in this case is only 40 pages. There's a syllabus about 15 pages, but that's the summary of the decision. I found that interesting. Justice Thomas, his concurring opinion is 57 pages, and all of it is about mostly meritocracy and the dangers of stereotyping. But interesting to read, and some of it is picked up in the majority decision. Judge Gorsuch's decision is 25 pages, but is probably the most strident of the positions in the decision in its totality. The cases that Ranking Member Scott was referring to about the current history of educational law was really based on the codifying of a case called Bakke. And Gorsuch calls that decision, which every constitutional scholar and educational expert has been relying on for that entire time, he just calls it incoherent. I think it's pretty well-established law. And so I think shorthand, incoherent must be shorthand for something else. He also says that the congressional intent that was established in that case to justify race-conscious programs was divined, that it didn't really exist, and that the court basically created that out of thin air. If you read the decision, you'll see why the court, in order to reach the conclusion that it made, had to dispatch with Bakke, and that's the way that he did it. Judge Kavanaugh wrote a short 8-page concurring decision. Interestingly, he acknowledges in his decision the need to give the ability to investigate and consider the historical impacts of discrimination, which surprised me a little bit, because then he joins in the ruling opinion. He says, but it is this temporal element that is bothersome to me, and so no program that is based on race should continue forever. And since this 25-year position, after which any race-conscious policy should not exist, is a part of that decision, that I think that because Harvard's program doesn't contain a temporal element, like a sunset provision, that I can't support it as being constitutional. But wait a minute, Harvard said in its argument, the 25 years hasn't run out. It doesn't run out until 2028, I think. And so we still have a few years, right? I haven't seen anywhere in the decision that answers that. They simply adopt this position that because there is no sunset provision of a race-conscious policy, that it lent itself to being unconstitutional. For the dissent, Sotomayor wrote a 69-page dissent. And you've heard one of the great quotes that she had. My favorite is after these attacks on Brown in the decision, she essentially says, Brown didn't stand for the proposition that color blindness is justice. It's that equality is justice. And the decision is not addressing whether or not this rollback is getting to justice. Judge Brown had a brief decision where she, Ketanji Brown Jackson says, and I just like this term, so I'm adding it in, that generations of state-sponsored race-based preferences created, quote-unquote, intergenerational transmission of equality. And there's something that we'd have to do about that. So with the few minutes I have left, I'd like to talk about what we can do about it.
Hi. Hello? Okay. My name is Tatum Anderson. I am an intern for Ranking Member Scott. And I kind of had a question about, you spoke on how in the decision there are nodes to no long-term racial based programming and also hints to no racial preferences in admissions, which, ironically is kind of what this whole Harvard admissions and affirmative action, was about. And so I kind of wanted to know, one, why do we feel like these schools kind of laid down once the decision was made, when determining the language, it's not preventing schools from, diversity initiatives? And also, what can we do if, the SCOTUS made this decision, but who is checking them on when there are white-based, preferences made in school admissions? If we can't have affirmative action, then where is the accountability on the other side?
That's a good question. I think the question is framed in the perfect snare that proponents of anti-DEI and affirmative action are trying to get you to frame the question in. I've spoken to lots of admissions directors and hiring managers about their responses to this decision. Actually, lots of institutions have put out public statements to say that they intend to consider to the fullest extent applicable to the law. Now, I don't know that they're laying down. Some are more forceful about it than others. But they also recognize that they are beholden to budgets that rely on the allocation of federal dollars or federal matching dollars or grant dollars that may be put at risk. An important and second level in this fight that Ranking Member Scott mentioned is on the heels of these decisions. State attorneys general in some states sent out letters to these institutions and said, if you don't change these policies or you continue on the path of race-conscious decisions, then one, we may no longer be able to represent you if we are the Attorney General and we're the state for your institutions, and you may be in violation of this Supreme Court decision. Those have yet to be tested, and I don't know if there's any scenario in which anyone has yet challenged them, but it becomes important even if those letters are a shot across the bow. And so there are opportunities that I think will come up in some of the decisions, some of these parts of the decisions that go to the four-part test of what makes something able to survive scrutiny or not, are really where the rubber's going to meet the road with those decisions. And so I think that there will be institutions who will maintain that they will have race-conscious elements of their admissions policies, and we'll have to wait and see whether the next decision results in a lawsuit or institutions start to kind of roll back their current policies.
Hi, is this on? Okay, perfect. My name is Chandler Fatah. I'm from Philadelphia, and I'm interning with the House Budget Committee. And I would really love to hear sort of your take on legacy admissions and how that sort of fits into the conversation, because it just seems a bit hypocritical that so many people were up in arms about affirmative action when legacy admissions at elite universities seem to give an obvious benefit to privileged students. So I'm just wondering how you think that plays into the conversation when we're talking about combating misinformation and really talking to people about this.
That's a good question. So the majority opinion and at least two concurring opinions both mention legacy admissions, which is interesting. In discussing things that are most likely to get an applicant pushed over that last hump to being admitted. They're analyzing the point system and the scoring system that the institutions are using. And so they specifically mention race, and they're obviously saying that that is unfair. But they also mention legacy. They mention extra points that one can get for the unique benefits that they bring to an institution by being an athlete. And one or two other things. There's actually six. And so there are critics of the legacy policies on both sides of this argument. And so some people that I don't know that they consider it hypocrisy understand that those are long and deeply entrenched benefits where an individual starts at the beginning of a race and his or her ability to finish. For those who are interested in this particular topic, Ketanji Brown Jackson, her decision in dissent goes into detail about this. And she uses the analogy of two individuals in a race. And one individual, Johnny, is a sixth-generation person applying to the school. So it's not only the legacy, but all of the benefits that are conferred on that individual. There are some people who have had the benefit of coming into applying for college with generations of people to even talk to them about what that means and how you do it. And those who are figuring it out on their own, maybe between themselves and Googling and hopefully a school counselor, right? And so those disparate impacts on history, if you look back to the legacy and the vestiges of discrimination that might be benefiting someone. She also uses that to underscore that it appears that the decision doesn't talk that much about this question about whether or not there are existing discriminatory policies or procedures or vestiges that people are still challenging today. And she wants to put that on Front Street. She definitely talks about that in her decision. And I would recommend that to you.
What about how this is going to bleed over into business opportunities, the Fearless Fund, for example?
Oh, wrote down Fearless Fund. Look at great minds think alike. Great. So, as I mentioned when I opened, if you read the decision, it talks about how historically discussion around limiting education opportunities that consider race-based conscious decisions ended up bleeding over into other areas. It specifically mentions government contracting first. Now, I thought it was interesting that they chose that because the tests and the measures of whether discrimination appears is very empirical for who gets contracts and what the contract dollars are. And I think they use that because it makes a very stark contrast between these amorphous concepts of what enriches a university. In fact, the majority decision says that the effort to achieve racial diversity of an institution is a noble one, but we may not be able to measure it at all, and we certainly aren't able to measure it based on the criteria that Harvard is using. But here they leave open this door, that if an institution can discuss its goals and objectives in a way that are measurable, which is a bit of a moving goalpost, but if it's different than this particular policy, then it would be one that merits a conversation. The Fearless Fund is referring to a fund that was woman-led, it was black-led, and was seeking to create economic opportunity and private equity investments. I should also say that challenge was also brought indirectly by the same interests that have challenged Harvard and UNC. Well, Harvard and UNC were exactly the same institutions. But many people believe that these are individual fires and challenges that are cropping up against affirmative action, race-conscious programs, D&I. And there's an individual who was behind most of those. And so it's not like that person came from an educational scholar position. There's also a challenge against wanting to have minority representation on publicly held boards. Those things are very different worlds, and yet it's the same individual. And it's the same individual who is finding individuals who can be test plaintiffs to challenge private equity for diverse persons. Anybody really wants to go on a rabbit hole on this can look at the transcripts from the court proceeding there, where the judge is challenging the defendant in court, who has to concede that the amount of investment funds that are going to funds of color is a rounding error of several zeros. And I think was substantially contributing to the fact that, at least at the court level, that was a factual scenario, that was empirical, and a basis to make a determination that these policies are supported. So I think one of those is that's a way forward, is that you look for empirical methods. Yeah, that's a good point. So I did mention that in any of these cases or policies or procedures where you are examining the challenges, you need to first determine whether the institution is public or private. So there are lots of institutions that are private, and they have a lot more freedom of discretion in what they can do with their policies. We can see that in at the distinction between the Harvard case and the North Carolina case even. One was predicated on you are a institution, though you are private, does access federal funds, and other institutions that are state colleges and universities or government programs or units like 8A and other programs from which people of color benefit. So you should know and understand whether or not the institution that is being challenged starts under which premise. We've certainly seen anti-ESG, anti-DNI policies reach into some of these areas, including 8A, the MBWE programs, other nonprofit efforts to benefit individuals of color, even private institutions that are creating scholarship opportunities for Hispanics or Asian Americans, or name your beneficiary. And they're citing to this decision in Harvard, which decidedly says that we are making a decision on the four corners of this document that this policy and procedure at this college and university didn't meet the standards. And so this is a sleight of hand that I think that many institutions are seeing with greater frequency. But you have to know and understand the differences to know to look out for them.
Questions?
Hi, Christian Haynes, Education and Workforce Committee. One of the places the decision was explicit about it not applying was to the U.S. military service academies. Could you speak a little bit about the decision and how that was explained and what implications that might have for the future?
So there are, obviously, there's always been a unique relationship between our investment in our protective services and including all the armed services. And it's not surprising that the academies, which historically have, out of necessity, in times of peace and war, long before many other institutions found themselves subscribing to the notion that individuals who are of different races would operate side by side, and that the highest performing and best achieving individual would be able to work with and compete for opportunities. The military has had a much better record at that. Now, it's not a perfect record. There are many people of color who have served this country for foreign wars and lots of times of conflict where those individuals were in the armed services but were relegated to menial tasks and service to other individuals who had the jobs of the pilot or the front line or the leadership opportunities. And people of color were in the armed services, but they were relegated to the positions of cook and digging ditches and repair and taking care of animals and mules. And that has changed. There have been a few articles, notes that have already been written about this carve-out, that the institutions that are the armed, I'll call it just the armed services academies writ large, are not subject to this rule. And those who are advocating on behalf of race-conscious decisions have been talking about whether or not that in itself creates an inequality, but they certainly don't want to be bringing cases against the proposition. That is not a policy that should be considered further. The armed services have said that they need to be able to retain and promote the best and brightest. And the reason that I think that this is important, I'm glad you asked that question, is one of the questions that was asked in the beginning of the case, that Harvard and North Carolina, actually it was the North Carolina decision, they sought to disqualify the plaintiff by saying that the plaintiff did not have standing. And standing means that you have to be a person, an individual who is aggrieved, and you cannot just create an institution that does not have members of the class that you believe is going to be aggrieved. The Supreme Court essentially said that though the plaintiff may not have had members when the case was first brought, by the time it was in court, they had actual members, and therefore the institution could bring that decision on behalf of those individuals. And the reason that that is important is on the issue of whether there is a valid, compelling state interest and a rationale for being race conscious, knowing and understanding when race conscious policies are no longer necessary, the institution said, we are the experts on what is most enriching to our institutions, and you should defer to us about when that no longer becomes necessary. And the court rejected that, but they accepted it for the armed forces, that they were willing to concede to the subjective determinations of the academies of whether or not diversity was enriching.
Other questions? Yes.
Hi, I'm Mary Gawali from Chicagoland area. I work with Representative Caston. I just wanted to ask you, looking towards the future, are there any specific policies Congress should be looking at relating to DEI initiatives?
In terms of specific policies, again, I would look to these 4 questions that the Harvard holding has set forth that are the basis for its determination that these specific policies cannot be sustained for these schools. One, there could be an opportunity to codify whether or not satisfying a test of the court that you've just not gone far enough is really elusive. In other words, you could create some policies and procedures, and the court could still say, no, not enough, right? And so this is specifically for strict scrutiny. This has been a problem that has really kind of bedeviled any developments in policy. The failing to articulate a meaningful connection between the means and the goals, I think, is a criticism that is instructive for actually litigants. That the institutions could be crafting a goal, an objective that's tied to something that is meaningful. But the most fascinating one that I think where there could be some legislative input is on this notion of whether or not a temporal element must be a requirement. If the decision essentially brings up the idea that that there should be some sunset provision, then any college or university that does not include that in the future going forward, I think is at risk of having its policy or procedure struck down summarily. And yet it is a concrete point that I think Congress could discuss. In fact, in attempting to fashion a rule or regulation that either protects that and says that if you concede that the need for race-conscious policies still exist, then the 25-year policy maybe shouldn't apply. It was really just kind of thrown out there. It was an aspiration, actually, expressed by a prior court. And so I think that there's something that could be done with that.
Hi, my name is Musab. I'm working with Congresswoman Jayapal. I'm curious to know, you mentioned that the institutions are still able to do data disaggregation and collect demographical data pertinent to their institutions. I'm wondering if the attacks against DEI policies, are those tending to be on the implementation of the data that's already been connected, or solely the root of the ability to conduct the data in the first place? And then if so, like, which is more problematic, and then how it can be addressed as policy changes?
I think the decision makes pretty clear that the collection effort is still a valuable and useful effort. And the question of whether or not it would violate any constitutional provision comes in as you apply that data.
Give Mark another round of applause for his comments. We obviously have a great interest in making sure that our colleges and universities are diverse, and that we counterbalance the obviously discriminatory factors that are left behind, so that we don't have only discriminatory factors deciding who gets into college and who doesn't. There are a lot of unanswered questions and future cases that we're going to have to consider, and since this is a holistic approach, there are a lot of different considerations. So we'd want to make sure that this doesn't get carried away into business opportunities. Where we mentioned the Fearless Fund, there's some opportunities where affirmative action is trying to be alive and well, where the opportunities, frankly, as Mark mentioned, hardly exist. You look at the amount of venture capital going a certain direction, and it's, what do you say, rounding error?
0.00.
It's not there, and with a little, if you don't want to make an effort to fix that illegal. So we have a lot of work to do, and the idea that this thing can be cured on a temporal basis is just aspirational anyway, because diversity takes a little intentionality, and when you stop being intentional about it, you start losing your diversity. And it's just not racial. I mean, it's geographic. Colleges like to have people from all over the country. If you're the only student applying to a college from Idaho, you got a really good chance of getting in, because they want that diversity. So we want to thank Mark again for being with us. And this is going to be an ongoing conversation. You may be getting another call from us.
Thank you for having me.
Thank you so much.
Thank you, everyone.